New Jersey simple assault lawyer. Assault charges in New Jersey can be classified into three categories of offenses: simple assault, aggravated assault, and assault by vehicle. While simple assault can be classified as the lesser of the three charges due to the exposure to lesser potential penalties, a conviction can still carry harsh legal and non-legal consequences. If you are facing a simple assault charge in New Jersey, you should not leave the matter of your defense to chance. Experienced New Jersey simple assault lawyer Adam M. Lustberg can assist in defending your rights. Our team of legal professionals works diligently to identify potential defenses that may apply to your situation, thereby increasing the chances of a favorable outcome. Top-rated N.J.A criminal defense lawyer Adam M. Lustberg discusses the elements of a simple assault charge. Under N.J.A law, simple assault can be charged when an individual causes, or attempts to cause, bodily injury to another. There is a lingering misconception that in order for an act to be considered assault, the injuries caused to another person must be severe, sustained, or long-lasting. However, this is not the case when it comes to simple assault. Causing even temporary pain or issuing a threat of physical harm can be considered a basis for a simple assault charge in New Jersey, even if the actor did not follow through with the threat of assault. N.J.S.A. Section 2C, 12(1)(a), 1. A person commits simple assault if he or she attempts to cause or purposely, knowingly, or recklessly causes bodily injury to another, or negligently causes bodily injury to another with a deadly weapon, and attempts by physical menace to put another in fear of imminent serious bodily injury. Simple assault is a disorderly person's offense unless committed in a fight or scuffle entered into by mutual consent, in which case it is a petty disorderly person's offense. Penalties for New Jersey simple assault charges. As a disorderly person's offense, a conviction of simple assault can carry the following penalties: a fine of $1,000 up to 6 months in a county jail. Possible simple assault defense strategy. Simple assault charges can be particularly tricky in that there is a very low standard on what constitutes bodily injury, as referred to in the statute. While this may be the case, the prosecution also has their work cut out for them in proving the elements of the charges beyond a reasonable doubt. A skilled attorney may be able to use the following defense strategies depending on the specific circumstances of the case. Coercion or duress. When a person is subjected to an extremely stressful situation such as physical, social, emotional, or psychological pressure, they may be forced to act in a manner that they otherwise wouldn't based on their established conduct without the stressor. Self-defense. If the person attacked was a threat to the defendant or caused the defendant harm, it is possible to mitigate the charges or have them dismissed by proving that the defendant only acted in defense of their well-being or to prevent further harm. However, it is important to prove that the defendant only used reasonable force in response to the initial attack and did not otherwise intend to cause undue harm and bodily injury. Defense of others. When using the defense of others as a legal defense, it is necessary to prove that the defendant used force to reduce the risk of harm or to defend other people who were being harmed. Mutual consent. In cases wherein there is a reasonable expectation that a person can experience bodily harm while participating in activities, such as sports, mutual consent can be used as a defense to have the charges dropped or reduced. To use consent as a simple assault defense strategy, it is important to establish that the extent of bodily injury experienced by the plaintiff in the alleged assault was foreseeable and reasonable based on the activity involved. Simple assault charges as a predicate act of domestic violence. When law enforcement responds to a call investigating a possible instance of domestic violence, when an alleged victim files a complaint, or when law enforcement observes signs of injury in a possible case of abuse, simple assault charges can also be filed against the alleged perpetrator of abuse. Under New Jersey law, when simple assault charges are raised in the context of domestic violence, the offense can result in additional penalties including the imposition of a restraining order. When charges of simple assault are filed as a predicate act of domestic violence, the defendant would essentially be facing two cases, one for the assault charge and another for the restraining order. Facing any kind of criminal charge in New Jersey can be a daunting and confusing experience due to the severity of penalties. Having a skilled lawyer who can protect your best interests and act as your legal advocate can lessen the uncertainty and anxiety of such a situation. Led by seasoned N.J.A criminal defense attorney Adam Lustberg, our team of New Jersey simple assault attorneys at Lustberg Law Offices is dedicated to providing clients with the best possible legal defense. We understand the significant impact of a conviction and can offer aggressive representation to protect our clients' rights and liberty. Contact us today at 201-880-5311 or visit us at 1 University Plaza Drive, number 212, Hackensack, New Jersey, 07601 to schedule a consultation.